Very good morning and happy Sunday to everyone. I very warmly welcome everyone who has joined to participate today in this humble free legal literacy initiative. We are Vestralex free online community classes on law. This is your initiative for you, by you, and only possible through the very kind and considerate blessings of our seniors at the bar in the bench. And we are here with you today to discuss a very important topic of Obiter Dictum, Obiter Dicta, with Honorable Mr. Justice Shri A.K. Ganguly, sir, who has been kind enough to grace us and to considerably give us this time today to discuss and share insights on what exactly is the concept of Obiter Dicta, of Obiter Dictum. So, very briefly, before I humbly hand over the class to Sir, I just want to introduce Sir for everyone's consideration. Uh, Shri Ganguly, Sir, Honorable Mr. Justice, was born on 3rd of February 1947. He graduated with a Master of Arts in English from the University of Calcutta in 1968 and then received a Bachelor of Laws from the same university in 1970. Sir started his career in 1969 by teaching at Hidarpore Academy, a school of which he was once a student. In 1972, he started practice in Calcutta High Court. On 10th of January 1994, he was appointed a permanent judge of the Calcutta High Court. He stayed as a judge at the Patna High Court for more than 6 years and was later transferred back to Calcutta High Court on 1st of August 2000. Here, he subsequently became the senior most puissant judge in March 2005. He functioned twice as acting Chief Justice of Calcutta High Court. Later, in March 2007, he took oath as Chief Justice of Odisha High Court. He joined the Madras High Court as Chief Justice on 19th of May 2008. He was eventually elevated to the Honorable Supreme Court of India, where he joined on 17th of December 2008 and remained as judge of the Honorable Supreme Court of India for more than 3 years. He retired on 3rd of February 2012. Post his retirement, Shri Ganguly worked as guest faculty at National University of Judicial Sciences, Kolkata. He also went on to be the chairperson of the West Bengal Human Rights Commission, where his role was highly appreciated. Again, this is a very small introduction, but I hope that it covers a lot of facets of Sir's careers. A few noteworthy cases are the 2G Spectrum case, the erroneous suspension of fundamental rights during emergency, and the president's power of pardon, among various other judgments. Sir, I very warmly and very humbly welcome you, sir, and I extend gratitude to you on behalf of all of our participants today. Sir, thank you so much for joining us. And, sir, I request you to kindly take over the class and enlighten us on the topic of Obiter Dictum.
Thank you very much. It's a great pleasure for me to speak on such an important topic in jurisprudence to the students. And I'm very grateful to the university and the authorities concerned for initiating this law training program. Now, to start with, an obiter dicta is a concept, and I have tried to analyze it in a wider perspective. This is a doctrine connected with the reading and interpretation of judgments. What is the outcome of a judgment? What points have been decided by the judgment? These are relevant considerations in locating obiter dicta in a judgment. Whether it is the judgment of the High Court or of the Supreme Court, and how does the decision of the High Court affects the district judiciary, and also the judgment of the Supreme Court affects the High Court in similar cases involving similar issues. These are the relevant queries in understanding the obiter dicta on a judgment. So, for a proper understanding of a judgment is also vitally necessary in the administration of justice. But then, how a judgment has to be read? The first principle that we must remember that the judgment cannot be read as a statute, and the judges are not prophets. not oracles. I mean, what they say, like 10 Commandments, that have to be followed by letter for word for word. For such proper reading of a judgment, one has to understand the concept of obiter dictum. As we are governed by the common law doctrine of jurisprudence, in our laws, judgments play as much importance as do the statutes. The words of legislation, as enacted in our country, do not have a final say in the justice delivery system. I mean, I will explain to you why is it so. This is clear from our constitution. Our constitution, Article 13, which is an article in the chapter on fundamental right, makes it very clear that in our country there are two kinds of laws. One is pre-constitution laws and the other is post-constitution laws. Those laws which were continuing prior to the coming into effect of the constitution are called pre-constitution laws. Say for instance the Contract Act, the Evidence Act, the Indian Penal Code and so on. And those which are post-constitutional laws, there are all the laws which are enacted after the constitution is coming into force. Now both the laws have to abide by the injunction of the constitution. What is it? Article 13.1 says that all pre-constitutional laws can continue on the condition that they do not take away or abridge our fundamental rights. If they do so, then that part of the law which is inconsistent with our fundamental rights will be declared void. And 13.2 says is even more emphatic. It says that the state cannot make any law. It is a clear injunction on the state. State means parliament, assembly, these are all part of the state under Article 12. State cannot make any law which will abridge or take away our fundamental rights. If the state makes it, then it will be declared void. Now my question is, who can declare a law void? It can only be declared by the higher courts. Therefore, when I say that in our country, the statute as made by parliament is not final, they're subject to scrutiny by courts, and the courts often declare them ultra vires or illegal or unconstitutional by a judgment. Therefore, the reading of the judgment is very, very important. And there are several judgments which are vitally important in the administration of justice. So both the high courts and the Supreme Courts under our constitution have the power and authority to interpret laws made by legislative bodies, and if on scrutiny of the laws they are found ultra vires, the constitution ultra vires the constitution, in such case such laws can be declared void, as I've explained to you, Article 13. And Article 141 is another important article which says that the laws declared by Supreme Court is binding on all courts throughout the territories of India. This is a special feature in our constitution. Both Article 13 and Article 141, these are two very special, significant features in our constitution. Therefore, in our country, it is constitutionally accepted that the courts, the judges also make laws. Because when you suppose you know that law under Section 377 of Indian Penal Code, where sex between same-sex couple was previously considered a criminal act. Now Supreme Court has quashed it. It is no longer a criminal act. There are several such examples which I can give, where the Supreme Court has edited our laws, have changed our laws. Therefore, the judgments are as important as the statute in our country. This Article 141 is based on the concept of stare decisis, which you must understand if you have to really grasp the concept of obiter dicta. Stare decisis is a general maxim which says when a point of law has been settled by a decision, it becomes a precedent which is not to be departed from afterwards. Stare decisis means to abide by the former precedents in order to keep the scales of justice steady and even, and make rule of law certain and predictable so as not to waver at every private opinion of a judges. What is a precedent and which is a binding force depends on the ratio decidendi of the case. Ratio decidendi means the precise reasons on which rests the decision of the case. And an obiter dicta is just the opposite of ratio decidendi. In order to understand obiter dicta, you must have a clear idea of what is the ratio decidendi. In that context, one has to understand the concept of obiter dicta. Obiter dicta cannot be defined with such precision as to afford an exact standard by which to decide when the text of a judgment is entitled to be considered a precedent and when it is to be considered an expression of an opinion of a judge which does not embody the determination of the court, which has been made by the way and without argument or full consideration on the point and falls in the category of obiter dicta. Obiter dicta are those kinds of opinions uttered by the judge and finding place in the judgment, not on the point of question decided, but as if turning aside from the main topic of the case to a collateral issue. If an expression of opinion by the court goes beyond the case, such opinions may be respected, but will not be treated as a precedent in a subsequent case when the same point again appears for consideration. Obiter dicta as a concept is always considered in contradistinction with ratio decidendi. Sometimes some obiter dictas are also authoritative, that the distinction between the two, namely obiter dicta and the ratio decidendi, sometimes is reduced to a vanishing point. Supreme Court in various cases have held that its obiter dicta are of considerable weight. All that is said by a court by the way or statement of law which go beyond the requirement of the particular case and which lay down a rule that is irrelevant or unnecessary for the purpose of the case in hand are called obiter dicta. These have the force of persuasive precedence only, but the judges are not bound to follow them. They can take advantage of them, but are not bound to follow them. According to Professor Peterson, obiter dictum is, I quote, a statement of law in the opinion which could not logically be a major premise of the selected facts of the decision. Dr. Goddard defines obiter dicta as, and I quote, conclusion based on a fact the existence of which has not been determined by the court, unquote. Similarly, in Keaton's jurisprudence, obiter dicta are described as, and I quote, statements of law made by a judge in the course of a decision arising out of the circumstances of the case, but not necessary for the decision. The Honorable Supreme Court of India, in the case of Arun Kumar Agarwal of the state of Madhya Pradesh, held that obiter dicta is a mere observation or remark made by the court by way of aid while deciding the actual issue before it. The mere casual statement or observation which is not relevant, pertinent, or essential to decide the issue in hand, the court said, did not form part of the judgment of the court and have no authoritative value. But there is a significance of Obiter Dicta, which I am going to explain. Obiter Dicta help in the growth of law and sometimes help the cause of reform of law. The judges are expected to know the law, and their observations are bound to carry weight with the government. The defects in the legal system can be pointed out in the Obiter Dicta. However, it is crucial to remember that Obiter Dictum has no binding effect as a precedent. In Mohandas A.N. Sanatham versus the Supreme Court defined Obiter Dicta as an expression of opinion on a point which is necessary for the decision of a case. This very definition draws a clear distinction between a point which is necessary for the determination of a case and a point which is not necessary for the determination of a case. But in both cases, points must arise for determination of the tribunal. Two questions may arise before a court for its determination. The court may find both, although only one of them is necessary for the ultimate decision of the case. The question which is necessary for the determination of the case would be the ratio decidendi, and the opinion of the tribunal on the other question, which is not necessary to decide the case, would be only an Obiter Dictum. Obiter Dictum was again discussed in Saran Singh Lamba versus Union of India. The Supreme Court talked about the value and the legal weightage of Obiter Dictum. The court said that in normal circumstances, the Obiter Dictum of the case is expected to follow. It was also held that the Obiter Dictum made by the Supreme Court has considerable weightage, but will depend on the kind of the dictum. In India, the Obiter Dictum of the Supreme Court are binding upon various other courts in India, provided that such dicta is on a question that arose for determination of Supreme Court. Obiter Dicta, nonetheless, assumes great relevance as they help to rationalize the law and suggest solution to problems to be resolved by the court. For instance, in Municipal Committee Amritsar versus Hazara Singh, the Honorable Supreme Court approved the following observation of the High Court of Kerala in the state of Kerala versus Vasudevan Nair. There I am quoting the judgment. Judicial propriety, dignity, and decorum demand that being the highest judicial tribunal in the country, even Obiter Dictum of Supreme Court should be accepted as binding. Declaration of law by the court, even if it done only by the way, has to be respected. But all that does not mean that every statement contained in a judgment of that case would be attracted by Article 141. Statements of matters other than law have no binding force. In the case of Oriental Insurance Company versus Meena, Varial and others, the Honorable Supreme Court observed that although an Obiter Dictum of the Supreme Court may be binding on the High Courts, it is clear, not binding on the High Courts, it has clear persuasive value even before the Supreme Court itself. The binding effect of the Obiter Dicta of Supreme Court has been reiterated in a recent decision in Peerless General Finance Investment versus Commissioner of Income Tax, where the Honorable Supreme Court observed it is incorrect to state, as has been stated by the High Court, that the decision in Peerless General Insurance Investment Company Limited must be read as not having laid down any absolute proposition of law, that all receipts of subscription at the hands of the SSE for these years must be treated as capital receipts. We reiterate that though the court's focus was not directly on this, yet a pronouncement by this court, even if it cannot be strictly called the ratio decidendi of the judgment, would certainly be binding on the High Court. Recently, the Honorable Supreme Court, in a decision rendered by Justice Sanjeev Khanna and M. Sundaresh, while dismissing a petition, reiterated that it is not everything said by the judge when giving a judgment that constitutes a precedent. The only thing in a judge's decision binding as a legal precedent is the principle upon which the case is decided. And for this reason, it is important to analyze a decision and isolate it from obiter dicta. As I have told you, that this doctrine can be understood only in a proper reading of the judgment. Now I'll shortly give you some idea as to how obiter dictum is different from ratio decidendi. Salmon, in his book on jurisprudence, defined the precedent in a judicial decision, which contains by itself as a principle. The underlying principle, which thus forms its authoritative element, is often termed the ratio decidendi. On the other hand, an obiter dicta is an announcement made by a judge in course of his judgment, which may not be unequivocally applicable to the issue before him. Ratio decidendi is more authoritative than obiter dicta. In contrast, obiter dicta has no binding authority. In state of Gujarat versus Utility Users Welfare Association, the inversion test to identify what is ratio decidendi in a judgment was applied. The test to test whether a particular proposition of law is to be read as the ratio decidendi of the case, the proposition is to be inverse, that is to remove from the text of the judgment as if it did not exist. If the conclusion of the case would still have been the same, even without examining proposition, then it cannot be regarded as the ratio decidendi of the case. This is the test. To remove that conclusion, that part of the judgment, whether the decision remains the same. If it does not remain the same, then the portion which you are removing is ratio decidendi. But if you remove a portion and even thereafter the judgment remains the same, then that portion which is removed is the ratio decidendi. So very careful reading of the judgment is most important. Now I have tried to explain this principle in the context of Article 13, Article 141, and this is very important because of a proper reading of the judgment. And sometimes the ratio decidendi, which doesn't go to decide the central issue, have a salutary effect on the judgment. Say these observations which will help in the later development of the law. Sometimes the court, while deciding a case, addresses the parliament, that the parliament has to consider amending the law in a different way, while not striking down the law. That helps in the development of the law. As you know, in the recent judgment, which is consideration, which is now being held by Supreme Court in the same-sex marriage case, the government of India is repeatedly saying that leave it to the parliament. You formulate certain questions and leave it to the parliament. If the court does that, then those portions will be obiter dicta, not the ratio decidendi. And that will help ultimately the parliament to develop the law. In many cases, after the Supreme Court has left it to the parliament for decision, the parliament has enacted the law. And that is how the development of law has taken place on the basis of Obiter Dictum. Now, this is the test as is made in the recent judgment, that if you remove the portion which you consider Obiter Dictum, the judgment remains the same, then it is Obiter. But if you remove that portion and that judgment does not remain the same, then it is not Obiter Dictum. Because the ratio decidendi is the backbone of the judgment. The entire judgment rests on that, the reasons for the judgment. And while discussing reasons, the courts explains it by several examples, by making several other arguments, other opinions, which do not go to the building up of the judgment, which is not centrally important for the judgment, but which are there in the judgment. And these are called Obiter Dicta. And why the Obiter Dicta of Supreme Court is binding on the High Court? Because of the doctrine of Article 141, which says the Supreme Court can lay down the law, can declare the law. While declaring the law, the incidental observations which are made by the Supreme Court may help the High Court in dealing with the legal questions which come before them. It's not very easy to locate the two, to differentiate the two. You will succeed in doing so, provided you read a judgment very carefully. But then judgments are not statutes. Every word is not that important, as if in a statute. In a statute, every word, every punctuation mark is also important. But judgment is an expression of opinion based on certain factual background. Therefore, the judgment has to be read. It is a habit which you acquire by experience. More and more you read a judgment, the more and more the light will come out of it. So these are my initial I'll take about half an hour to explain the doctrine. Now, if you want to ask me any question, I'll try to answer them.
So thank you so much. That was very enlightening, and I'm quite sure that it's provided certain facets which are absolutely very relevant for everyone to understand. Mostly, I think the one thing which you mentioned, that Obiter Dicta is binding on high courts through 141, Article 141. It's very, I would say, revealing and enlightening.
No, I don't say it is binding because of 141. I said 141 is a concept in our constitution which is very peculiar to it. It is not there in any other constitution, which gives the Supreme Court the authority to make laws, declare laws. And it has been said declaring laws is wider than making laws. Because while declaring a law, the Supreme Court has to consider many things, and many questions are discussed. So what is discussed, which may not be central to the making or declaring the law, but which are relevant, those will be Obiter Dicta, and those relevant discussion is also binding. The way the Supreme Court formulates its proposition, these are also binding.
So, sir, one very interesting question which usually comes up. So, I think Vinod sir has a question.
Sir, good afternoon, sir.
Welcome, sir.
Good afternoon, yes.
Sir, when we say that under 141, when certain observations are made by the Honorable Supreme Court while declaring a law and those obiter or those things are binding on the high courts, then to that extent, shall we presume that there is no difference between the ratio and the obiter? Or we say that the obiter is only, even under 141, is a guiding guidelines or a guiding star as compared to the ratio?
No, you're right. It is said that sometimes the difference between obiter and the ratio descendendi have reached a vanishing point. They have been sometimes reduced to a vanishing point. because there are some obiters which are so intermittently connected with the ratio. It's very difficult to distinguish the two. Therefore, what I'm telling you repeatedly, it is only by repeated reading of the judgment you can find out what is obiter, what is not.
What is ratio? Thank you, sir. Thank you.
Supreme Court has said so that the sometimes they are so intermittently connected, intermingled, that they have reached a vanishing point. The distinction between the two. A very pertinent question.
So,
Great.
absolutely. And thank you so much, Vinod, sir, for sharing that wonderful question. So, there is this other thought where, so I'm trying to bring in the aspect of young lawyers also. And so most of the lawyers, they don't get an opportunity to practice or appear before the Honorable Supreme Court, and understanding the various practices, procedures, which are absolutely very different. How arguments are also taken forward in the Honorable Supreme Court, that on regular days you have arguments which are actually all advocates are heard at length. So there is a lot of conversation which happens during the course of the trial. There is a lot of queries which the honorable judges also have. A lot of things that lawyers also, they want to contribute, but mostly, sir, considering that we're speaking about obiter dicta, so are everything which is spoken about by the judge in the course during the course of the trial, does everything form a part of the obiter dicta, or would it necessarily restrict only to the words which have been written down in the judgment and what may be inferred from that?
No. Oral observation do not form part of the judgment. They are neither obiter nor ratio. What is written in the judgment, only there you can call out what is obiter, what is ratio. Oral observation do not form part of the judgment. These days there is a tendency to report and publicize even the oral observation of the judge, and then to create a sensation. Many oral observations made by the judge in order to properly elicit answer from the arguing counsel. They, as the way they are reported next day in the press, people get excited that is the judgment. That is not the judgment. Those who are connected with the justice delivery system, you say that the judges ask various questions in order to get the proper assistance from the arguing counsel. Judges have doubts in their mind before they decide. They must dispel their doubts. In order to dispel their doubts, they ask questions they're entitled to. They may sometimes make some comments because judges are not machines. While asking questions, they may make some comments, and that is being reported, unfortunately. There, the case reporting has to be more responsible, and that creates sensation. It says in the next morning newspaper, Supreme Court says this. But the Supreme Court has not delivered any judgment. Say that the recent famous case of same-sex marriage. Every day there are sensational reporting. Every day the judges are resenting it, but the newspaper, I'm sorry to say, I have all respect for the journalists, they are not listening. They are making sensational reporting next morning. Even these days it's coming on the TV, online, it's coming. Now the Supreme Court has now made it, what is going on in Supreme Court is now can be streamed online. You can see this. There's a lot of transparency, but the transparency has a virtue. But the transparency, one has to understand the virtues of transparency. You do not sensationalize the entire thing. The Supreme Court thereafter may not deliver a judgment about the conversation which is going on in court. That is just for the purpose of eliciting answer. The judges have to dispel the doubts. That is their right to do.
So, absolutely, sir. And it's a very pertinent issue which you raised today. And so this is also in line with how lawyers are getting access to courts today. So, primarily, sir, there is a lot of information, a lot of court streaming is happening on YouTube. So, live court proceedings of the Honorable Supreme Court, various high courts are also are streaming whatever court live proceedings, and
Yes,
lots of sensationalized small clips are also being circulated on the internet. So it becomes very, so for a normal person, for a lay person who is not a lawyer, how do they understand what is the relevant bit that they should
they are
probably?
misled. Most of the time, they are misled. I am a retired judge. I am bombarded with questions by my friends and others that your Supreme Court has said this, and wait for the Supreme Court to deliver the judgment. No, no, it has said so. I know, how can you say so? Even the Supreme Court speaks through its written judgment, not oral observation. What is binding on Supreme Court is a judgment under Article 141. That is where it lays down, declares the law. Not all case it may not declare law, but the controversy is set at rest. Therefore, today the judge's job is becoming more and more difficult because there's a lot of pressure on them, a lot of expectation from them, and the entire society is looking up to the judiciary as protector of their rights. And judiciary is trying to do its best despite so many constraints. Therefore, one has to be very patient with these observations. Now, Supreme Court has said, may say one thing in a particular bail case, then everybody is saying the Supreme Court is letting out all criminals by granting bail, and bail is not letting out criminals. Bail is not acquittal. Very few people fail to understand the distinction between bail and acquittal. At the time of granting bail, Supreme Court makes some observation, grants bail, maybe some reasons, and they are reported widely in sensational cases. I am bombarded with the Supreme Court has let out this criminal. No, it's granted bail on certain consideration. Say trial is not held, Supreme Court says the age of the accused. So many considerations have to be there. So, so these are very difficult and touchy issues. It's a live issue, no doubt. It is concerning our lives, our social interaction, our social equation. There was Supreme Court and the High Courts, and all courts have a very vital role to play in adjusting today's complex social equation, social relationship.
Absolutely, sir. Absolutely. I think everyone who's here, they understand this one thing, and so this is one thought which has been more solidified with this conversation with you as well. So there are other thoughts also. So we try to have a mix of all sorts of people. So there are quite senior advocates also who have joined us. There are also people who have been on the part of the judiciary as well, from lower judiciary as well. So we've just tried to have a normal community sort of a setup wherein people can be from every place. So there is this one question from Mr. Prashant Kumar, which he has asked from a general person's perspective. So what he has been able to understand, sir, and what he says is that as obiter dictum do not create a binding precedence, why is it given so much importance? What is its true value?
Its value is, as I've told you, its true value is it helps in development of the law, depending on the nature of the obiter. Sometimes obiter is loaded with lots of reasoning. It may not form the central reasoning which is responsible for the judgment. But obiter dictum is also something written in the judgment, which is also a reasonable, a rational expression of mind by the judge. And if it is the rational expression of mind by Supreme Court, it carries a lot of weight and guidance for the high courts to deal with similar issues.
So another interesting question which stems from this, and so please, I'm so very grateful to you for listening to all of our questions, but I also hope to just convey to you that so we are, it's an academic group, and we're just trying to be as good students and try to ask as many questions as possible. Sir, there is a lot of so sometimes, sir, the honorable courts, what in the orders itself, there is an application, say, for grant of stay as well. So the honorable judge may not feel that I want to grant stay right now itself, and there is probably something like issue notice of stay or reply for stay application may also be filed. So what is the kind of an impact that, as per your kind understanding, sir, it creates, or how can an advocate and how should an advocate represent that when they go before the High Court with such an order?
No, you're saying in a situation where the court refuses to grant ad interim stay.
Yes, sir.
I mean, the court says, I will not grant ad interim stay. I will hear the other side and then consider whether stay should be given. Then at that stage, the question of stay is sub judice before the Supreme Court. The High Court, the learned lawyer going before the High Court can say, my lord, do not hear the matter further till the Supreme Court decides on the issue of stay. The Supreme Court has issued notice on the question of stay. It has not granted stay, but it issued notice on the question of stay, because it may grant, may not grant stay ultimately, but at the present moment, there is a possibility that it might grant stay. Supreme Court is prima facie, because unless Supreme Court is prima facie satisfied of the case, it would not have issued notice. It would have dismissed straightway. The very fact that Supreme Court has issued notice, Supreme Court is a little satisfied on my prayer for stay, but has not granted an ad interim stay because the Supreme Court is satisfied there is no irreparable injury. So it wants to hear the other side and then grant me, either to grant me stay or may not grant me stay. But at this moment, Supreme Court is in season with the matter on the question whether to grant stay or not. Therefore, High Court should stay its hands for the time being.
So it's actually very, how do I say? It's very convenient. Absolutely. How you teach also, so how you tell also, it registers quite easily and well, actually. And I think same as reflected in all of your judgments as well. So, similarly, in line with duties of advocates when they are speaking with lawyers, when they're speaking with the bench per se. So sometimes the thought is to try and gauge what exactly is the idea of a judge, or what exactly does the judge think about any such question which the lawyer may want to bring up. So any strategy advice wherein probably something may be brought in such a manner that it may assist, or some guidance tips for lawyers primarily, I would say.
See, it is very difficult to read the mind of a judge, extremely difficult. And these days, it happened throughout also when we were at the bar, when we were on the bench. The judges change. We appear before a particular bench. You can think the judges are thinking this way. But when your matter comes up for further hearing, it may be before another bench. So these are the eventualities in litigation. These you cannot sort of control. There is a chance factor in litigation. Suppose you have a case, and if it goes before Judge A, you are going to get a favorable order. But if it goes before Judge B, you may not get any order at all. This happens. Because judges are not automation, they are not computers. You press the button and you can't get it. You see, there is a famous statement by Judge Cordero, one of the most finest judges, that however impartially we want to see a thing, however rationally we may want to see a thing or judge a thing, we judge it or see it with only our eyes and nobody else's eyes. Judge's perception. Suppose you come to me and you go with the same case to another person. So this has happened mostly in the cases of death penalty. There are some judges who are averse to death penalty. The death penalty is now sanctioned under our law. But there are judges who are averse to death penalty, and there are some judges who are quick to it. This has happened. I mean, if you look at the jurisprudence of death penalty, you will find it. Therefore, this is the glorious uncertainty. It is there. You cannot predict what is going to happen in a case. Normally, your prediction may go right 80%, but there is that gray area of 20%, which you cannot predict.
A lot of research happens before every matter is listed, especially before a new bench. So people try to go through all previous orders, try to see what exactly
Yes, 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 yes.
how has the bench thought.
I'll tell you, I'll share you my experience. Because in Calcutta High Court, I was a lawyer. In all high courts, it has been a system that the Chief Justice comes from outside. The Chief Justice comes from outside. So when in Calcutta High Court, a particular Chief Justice, say, comes from Gujarat or comes from Bombay, we used to look up his Lordship's judgment in that High Court where he was and what view he has taken, and used to fashion our argument matching that view. And it used to work because the same judge, maybe in a similar or somewhat similar case, expressed his views and delivered a judgment in the High Court where he was there. Now he is now shifted to Calcutta High Court as Chief Justice. His views won't change overnight. But I have found if you address him on those points in your argument, highlight those points, you are likely to succeed. And this has happened, I tell you. I can tell you from my personal experience. We used to look up his Lordship's, the Chief Justice's views, because he's coming from a court which is known to us. Maybe from Madras, maybe from Gujarat, maybe from Bombay. These are maybe from Delhi. We used to try to look up from the AIR, from these, look into index, what was his Lordship's views on this point, whether his Lordship has delivered a judgment on this point. If he has not delivered, it's not delivered. Sometimes he might have delivered. Similar questions might have been argued by, might have been raised before his Lordship. So this thing happened, but it requires a lot of study. The legal profession is not an easy profession. One must get, if I may say so, one must get glued to it. One must get himself involved in it. What is called, there is a very good Sanskrit word for this, sadhana, dedication.
Absolutely.
That is most important.
So, but it's also, I will just humbly want to just put in the fact that, sir, when we have gurus such as yourself, so sadhana is, I think it flows to everyone.
I am no guru, but I can just share my experiences with you. Some of them. There are many various ups and downs, and I am a first generation lawyer. So everybody has a scope. In this profession, there's a lot of scope. You have to be patient, hardworking, and persevering, and don't lose hope so easily. Lose one case, you may win the next day a bad case. You may lose a good case today, but you may win a bad case tomorrow. It's a long line.
So very recently, sir, if I may, if with your permission, I'll just humbly take 2 minutes to share this one thing which very recently happened. So in the Honorable Supreme Court itself, so there was this one particular matter wherein a friend of mine, a colleague of mine was appearing, and not himself also not appearing. One of his seniors had delegated the matters to another junior who was taking lead in that matter. It was a bail application for about a lady of some 70, 80 years age, apparently. Whatever matter was absolutely technical, and Honorable Court was abreast with the matter. So they did not grant bail in that particular case due to whatever reason, whatever may have happened. So he was devastated. He was devastated. He thought that now for at least another 3 to 6 months, I don't know how or what will happen. that lady, she will also have to suffer whatever has happened due to whatever.
And normally, a lady of 80 has a good chance of getting bail. Normally.
Absolutely. So that is why he was devastated, and that is the reason why the matter was assigned to him. So, uh, but it's just a thought. So it's just a thought. Anyways, I'll come back to this topic itself. So there is this question which says, this is by Mr. Kashyap from Kashyap Law Offices. He says, per incurium decisions strictly is applicable to ratio decidendi, but not to obiter dicta. And then so he asks why.
So a decision which is par incurium means a judgment in ignorance of the relevant law and the relevant statute. So if it is par incurium, then there is no ratio in that case. There is no question of because in a hierarchy, ratio comes first, then comes obiter. If there is the judgment itself is par incurium, there is no question of a ratio. Where is the question of obiter? The judgment has to be ignored. I mean, the judgment par incurium is judgment which has to be ignored, which is completely not taken care of the relevant statute, the relevant law declared, the existing state of law. Then it's not a judgment. Judgment par incurium is not a judgment. It has to be a judgment first, then the ratio will come, then the obiter will come. If it is not a judgment, there is no question of it doesn't have a ratio. It falls through. Therefore, it cannot have an obiter because obiter, as I have explained to you, does not come in the same grade as ratio. It falls below second class. Top class is the ratio which decides the case, which is the fulcrum of the case. And now, if there is no ratio, in a case where the judgment is vitiated by par incurium, is judgment delivered par incurium, then there is no ratio. If there is no ratio, there is no question of a ratio decidendi of a par incurium judgment cannot take place.
Absolutely, sir. Absolutely. I hope that clarifies to him. So there is this question which says, is it that only final judgment is part of ratio and other observations being part of obiter, or there is something more in this filtration process? This is by Mr. Prashant Kumar.
Yes, final judgment. The ratio is all meaning the ratio in the final judgment, not an interim order. Interim order is a position where the case has not been decided. Ratio is in a judgment. An interlocutory is an order, not a judgment. Judgment means something which is a finality. Unless the whole thing is final, the concept of ratio decidendi or obiter dicta does not apply. There is no question of an obiter in an interlocutory order. Interlocutory order, some questions are to be decided. The prima facie is always decided prima facie. On many occasions it has happened an interim order is given to the litigant, but ultimately his case has been dismissed. Interim order does not finally decide the controversy.
Absolutely, sir. Absolutely. So again, there's a lot of confusion, I think, with respect to where the obiter dicta ends or where the ratio decidendi ends and where the obiter dicta starts. So there's this question by Mr. Himanshu Atri, sir. He asks, overlapping probabilities of both gives discretion in order to decide what is OD and what is RD. What is obiter dicta and what is...
It is very difficult to sometimes. It is very difficult to distinguish the two. As I've told you, as there was a previous question, that sometimes the dividing line between the two has reached a vanishing point. Very difficult. You have to read the judgment very carefully to locate where lies the ratio decidendi and where lies the obiter. Sometimes they are so closely mixed up, it's difficult to differentiate the two. It is very easy to say than to find out. The doctrines are there. As I've said, that Obiter Dictum is very difficult to describe the doctrine in precise terms. I can say it is not part of the final reasoning process. But reasoning is such an involved mental exercise. Many things go into it. Reasonings in a judgment, it depends on the reasonings in a judgment. Sometimes while giving reasons, the judges give illustrations. Illustrations are certainly not part of the ratio decidendi, maybe part of the obiter dictum, but there are maybe some illustration which is central to the reasoning, which itself is a reason. Therefore, it is advised that the judges should be very careful in delivering their judgment. There should not be confusion. If the judgment leaves many things in a state of confusion, then it becomes more difficult. The judgment must be clear and specific. Then it is easier to distinguish the ratio decidendi from the obiter.
Absolutely. So, any just very briefly, sir, any considerations that one might want to keep in mind when they are at the stage of determining what exactly?
As I've told you, the last example I've given. If you take out a particular reasoning from the judgment, and if thereafter the judgment remains the same, then what you have taken out is not the ratio, maybe obiter. But if the judgment does not remain the same, if you take out the reasoning, then that is the essential part. That is the ratio decidendi.
Absolutely, sir. That's really
the last example which I gave you.
That's very clarifying. Actually, that's very clarifying. So I just have one question that I want to ask you. Apart from that, any question which anyone else has, please, right now is the best time if you want to ask that question. So there's a question from Miss Madhavi. She has asked, if an advocate fails to represent properly during any argument or forget to include relevant sections pertains to any application during argument, then can the judges intervene and take suo motu intervention and give appropriate justice, or the judge has to decide only on the arguments which have been advanced?
No. Judges' duty is to decide correctly. If relevant arguments or the relevant section is not placed before him, the judge has to constantly research when argument is going on. Then if we on a research, I have done it several times. On a research, if I find something relevant to the case, some section, some judgment, then I bring it to the notice of the parties. This is what I found on my research. What do you say on this? Should bring it to the notice of the parties, give them an opportunity to argue on that. Then he can, because it is, after all, it is the judge's responsibility to decide correctly. He must not deliver a half-baked judgment. Then the whole thing is not decided, then it will lead to further litigation. It is his duty to deliver the judgment correctly. Maybe the learned lawyer has not made the research. The judge has to do the research when argument is going on. This I have done several times. On my research, I find something relevant and bring it to the notice of both the parties. This is what I have found in the course of my research. What do you say to this? Give the parties a chance to look into it and address the judge on that point. That should be done.
So, in this light itself, there was this very interesting thing which was discussed very recently. So, again, in the Supreme Court canteen itself, there was a discussion that a very similar question arises during PILs. That a lot of people, they file half-baked PILs due to whatsoever circumventing or whatever thoughts they have, they want to either propagate, or sometimes there are vested interest also. So we had one class on public interest litigation also some time back. So there this particular point was raised that due to such inadvertent applications or frivolous sometimes petitions which are filed before the honorable courts, that a lot of rights, genuine rights of people, they get curtailed. Uh, so in this respect, if there is any thought that you want to share with us.
No, Supreme Court has already laid down that if a PIL is not is filed on a frivolous matter, or if a PIL is filed with a proper research, the Supreme Court normally dismisses its heavy cost. Supreme Court has done it. Supreme Court has laid down this principle. There are judgments on that.
Absolutely, sir. Absolutely. So, sir, thank you so much for the time that you've given. Now, sir, now I very humbly want just 2 minutes of liberty from you for one intriguing question that I have, and I hope that you'll find it appropriate. So, sir, what I understand, so the reason why we discussed Obiter Dicta also today is that a judge has very limited expression for himself. There is a lot of sacrifice the moment a person chooses judgeship. That moment onwards, they have very little, I would say, public life. It very much it ends right over there itself. And apart from there, also, whatever, if they're sitting at the bench, whatever they say, every advocate who's there or any person who's there, they want to analyze every single word of it. So what? So how exactly does a judge find his speech, sir? We talk about freedom of speech for everyone, but the reasonable restriction over a judge is it not just too much? And where do judges, sir, where do they get to speak?
No, the judge's freedom of speech on the bench is severely curtailed. It has to be, because my personal opinion I cannot voice. While sitting on the bench, my personal opinion I cannot voice, because one of the fundamental principles of, of judgeship is that you should not decide on the basis of your personal opinion. My personal opinion on a subject, I cannot sort of preach. I cannot
Your
speak
opinion.
on. No, you have to eschew that. You have to decide the case on the merits of the argument, on the merits of the facts, as argued, as decided by different. I personally, I may not like death penalty. Personally, I may be opposed to it. But even then, when I'm sitting there as a judge, I must follow this is what is known as discipline of law. The discipline of law will curtail the judge's freedom of speech. Because your office is such. You must appear fair to both sides. You cannot take a side, take a particular view and be completely close to another point of view. You must have a mind quite open.
So I understand. So again, it's very challenging, and for all of us young people, I think it's something which we have to go along the way trying to understand and learn. Uh, but sir, I cannot in words express gratitude to you for taking time out and so addressing us on this and speaking to us on this very important topic.
Thank you also. Thank you very much. I also enjoyed it.
And
Enjoyed the interaction and the questions.
I thank you on behalf of all of our participants. And so you've been so gracious and so kind to listen to us, all of these trivial questions also, and so kindly and so
That
enlightening.
is one of the judge's quality. He must listen patiently. That is one of
Sir,
the qualities of a judge. Though I've retired long ago, but these things are in me, ingrained in me. You must listen patiently.
and so it is deeply appreciated, sir. And it is, sir, I was just thinking about this topic. It made me think so much with respect to expression of a judge, and it made me that it actually is a very difficult job, sir, because I've seen judges listen to people go on and on and on and on, how maybe I am doing right now, and yet they have to sit and listen, and they so kindly listen without even losing their temper.
All the best. Thank you.
So kind of you, sir. So
I
kind of
wish all of you to prosper in your profession and do well.
Thank
Have a
you so
nice
much, sir.
time.
Thank you so
All
much.
the
So kind of
all
you.
the
With your permission, sir, I'll end the class today.
yes.
Yes.